session now to enlighten us on the ICT inventions and patent perspective in India and Europe. We have with us Dr. Ajai Garg, Director, Innovation and IPR Division, MIT, Government of India. I would again like to welcome Dr. Ajai Garg on stage, who is an experienced technocrat and a veteran in the intellectual property rights issues. Dr. Ajai Garg.
Thank you, and sorry for being here. It's an occasion where I feel that I'm only giving something which I myself have never implemented. And as all my generation has been doing, we have just been spreading gyan rather than making difference on the ground. And it gives me so much of satisfaction seeing Kunal and Prabhu and all these people who are actually making difference on the ground. Thank you. Thank you once more for giving me an opportunity to listen to you guys and keep doing well and make this nation proud. The topic for my discourse right now is that ICT inventions in the perspective of India and EU. Let me divide it into two aspects, India and the developed ICT economies. India is since Y2K, has greatly benefited from the ICT revolution per se, in a sense that we became a world leaders in the outsourcing business, which is of the tune of around $150 billion of date, nearly 56% of the global markets. And because it was an outsourcing business, the IP belonged to someone else, and we were just serving our clients. IPR was not the core issue with regard to the ICT sector or the IT sector per se. We missed out on the bus, we missed out on the opportunity of the bus to create a manufacturing ecosystem in this country, especially in around electronics. And as the rest of the world, we became net importers of electronics. And we have reached a situation that if we do not do something, then our electronics imports by 2020 will reach a tune of $400 billion, which will be more than our oil bill or oil exports. And that's an alarming situation. As far as the services or the outsourcing business is concerned, it's also going through the challenging times. As a very knowledgeable comparer of ours, she's more experienced in the ICT domain than she has done her homework very well. Said that why we call it as a challenging times. Because for two reasons. There is a very famous economist from the Cambridge, a Korean called Professor Chan, who wrote a very interesting book called Kicking the Ladder. What it really says is that the rules of the game have been defined in the last 300 years by the West. And they keep advocating you you will move and reach a platform where your economies will be as matured as ours. And that's the way they drive businesses globally and create markets, and have very intelligently used the WTO in doing so. But the underlying principle in that, or the catch in that, is that the moment you do the things as dictated by the West, they remove the ladder for you to reach the top and create parameters which are different. And they say, now you have done this, now you do these things more to reach there. So that's where the catch is. And so in that aspect, they advocated that you open up markets, loosen your immigration systems to allow our goods and services to flow into your market, and we will give you a reciprocative immigrations and free access to our markets, and you reach there. But the moment our IT services started doing that, the West has started entering into protectionist regimes, and the immigration laws are getting tightened, and EU never allows you to let the data flow out from their geographies, because data is the future oil of the world, and he rightfully talked about data, and I'll say where the opportunity lies in the later part of this talk. You must be reading the newspapers of today, where they have actually increased, doubled. They are talking about, the US Congress is talking about the minimum salary brackets for IT professionals, and that's the way to actually put embargo on our services market or outsourcing markets in US. That's one challenge. The second challenge is the technology challenge, because now the artificial intelligence and data mining has really matured out there. So the IT outsourcing of services will be replaced by automated tools like AI-based automated tools or IoT-based automated tools. And so outsourcing as a productivity enhancements tool that the top 500 companies were using might not be very relevant in tomorrow's time. And we need to rethink that how do we actually change our business strategies to remain relevant in global markets, and how we leverage the opportunities created by artificial intelligence, big data, and IoTs. And we need to encash on these opportunities in near future, because as I said, we are 150 billion, which is 56%. So the services market or the outsourcing market as of date is of the tune of $300 billion globally, but the total IT market globally is 1.2 trillion or 1,200 billion. So we are just working in the 25% space of the total IT market. In the rest of the 900 billion, our contribution is just 4 billion. Our product industry or the solution industry is just 4 billion as of date, and we just have that captured 4. And the future statistics says that the outsourcing market will diminish by 5 to 7% annually, whereas the rest 900 billion will grow by 18 to 20% globally to reach around 2 trillion by 2025. So here we need to rethink our IPR strategy in the ICT space. Software is a very typical subject as far as IPR is concerned, and why did we actually not sensitively or proactively dealt with it is a reason specific to software, is for two reasons. As my earlier speaker told about that in software space, because software has an underlying technology that actually creates the algorithm or system design around it, which is then coded well to create a software. So the first part is the technology, the second part is the literary art. So technology traditionally are protected under two regimes. If you need a long-term protection, or you need a protection which is then go for a patent protection which gives you a 20 years protection on the underlying technology. And if you see that the patent protection is difficult, and the patent protection, because of the incremental nature of IT, will not give you sufficient benefits, then you keep it as a trade secret. The second part of the literary aspect, and because software is a typical technology which always remains intangible and easy to copy, and where the copyright systems work. So the copyright protection is always an important aspect of protection of software to avoid mass copying, and so it has to be protected as a copyright. Now, since we did not have any products, we did not have any system designs in place, so in the IT space, we were not concerned about patents traditionally, because they gave protection to incoming technologies. And we were not very critical that patents because someone talked about a figure of 48,000 patents being filed from India annually. But do we understand that of those 48,000, 83% of those patents are through the PCT route for technologies that are coming into India and looking India as a market? We as Indian innovators and inventors just file around 10 to 12,000 patents, and in the ICT space only 500 to 700. And of that, many of them are from the public funded institutes that file it for the sake of filing, and the strategy or the commercialization that someone talked about, because most of the issues have been touched upon earlier. And what is the strategic relevance of the patent? No one has actually, they are very few in number. We have got a scheme where we provide 50% support to international patent filing, and that's to a tune of 15 lakh rupees per patent. And I as a policymaker think that it is one of the most open and very little regulated scheme, very easy to obtain. But the sad part is that we have kept a target of 200, a very modest target of giving support to 200 patents in 5 years. And I know I won't be able to reach that target. Not for the reason that I have rejected most of them. We accept 90% of the applications that come, but they are so little in number that we will not be able to reach 200, because there are very few Indian innovators or inventors who are filing abroad. So that's the first issue. Whereas the copyright is concerned, because software in India was an inbound software, whether it's an OS or an Office which are of high relevance, the licensing fees was so high that people used to actually to make ICT and its benefit reach the last mile. The only method that was available besides using the open source software was using pirated product. And if you get into the regime where the Copyright Act and the sections 50 and the 50A and 50B are strictly implemented in this country by the lawmakers of the Copyright Act, then I think 60% to 70% of the Indian population will be behind jails or facing civil suits. So those were the two issues why we in the software space did not take the IPR and its underlying laws very seriously. But the times are changing, and if we have to actually take our IT industry and forward, and that's not because we want to support the industry per se, because it's a buzzword to be in the IT space, but let's understand that it's the only sector that is providing a huge amount of white-collar jobs. And it's a social need to protect this and play the game rightfully. And that was the reason the government came up with the national IPR policy, created an organization called CPAM. And it was the first time that IPR moved out of the clutches of the lawmaker, of the lawyers. How many lawyers are there? None. Actually, it's one of the few. So that's a reflection that it might be one of the very few conferences which are only attended by IPR attorneys and not by the real users of IPR. Real users of IPRs are the industry. So if you go around into Delhi, Mumbai, Bangalore, and if you attend an IPR conference, 60% of the audience will be IPR attorneys because they have markets through IPR. None of the other people have. But the times have come when you all have markets from IPRs rather than only the attorneys making money out of it. Obviously, when you have, they will make money, but you will also make money. So the CPAM is, or the national IPR policy, it has done only one thing that is important, besides what are Articles 1, 2, 10, 12, whatever they say, and their words, but it has done one thing which I feel very satisfied about. It has moved IPR from a legal subject to a management subject. CPM is management, Center for Intellectual Property Administration and Management. And that's the place where we have moved. In the software side, we have first time came up with guidelines which defines that how do we actually rightfully protect software through patents. Our Patent Act under Article 3K says that computer software per se is not a patentable subject matter. But what is per se, no one has defined it before. The 2016-17 guidelines have defined it. And now there is a good chance of you getting a software patent if it has an underlying technology behind it which connects to the hardware and creates a industrially relevant application. Then Raghu talked about plagiarism, and it's very prevalent in the schools. The CPAM is actually touching on the school, and where we are actually talking on subjects which the school student needs to know. That how ethically he has to use internet, how he has to be ethical, that not only creates innovative products and ideas, but also be sensitive to someone else's creativity and not infringes on others' right. Because if we see, many of our very innovative products have fell through because we were not very sensitive to IPRs. A very simple example is a very low-cost computing device called Computer. When it reached the US markets, it was flooded with n number of IPR suits, and a very innovative and a product and a business proposition got killed because of the IPR systems. Now, as far as software is concerned, there is also one very underlying principle that software traditionally is a mathematical subject. An algorithm is a mathematical formula as such, which the software says. And a mathematical formula or basic science is never protected as a patent by the patent system per se. But because it had high industrial value in US, and with software getting detangled with the hardware and was independent industry with the coming up of IBMs and Microsofts and Macintosh in the 70s, and desktop computing becoming important, software was granted as a patent. And the same happened with the pharma industries in the early 19th century, because pharma also have no logic for patents to be granted. When the patent systems were evolved in the 17th century, it was around the era when machines were coming into, after the Newton's 3 laws, machines were coming into the market. James Watts and others started inventing new machines, and they wanted a limited period of monopoly for those machines to succeed in global markets. And the patent system evolved around machines. So it was basically for mechanical systems, for machines. Then with electronics becoming important in the early 20th century, electronics came into, but it was never made for pharma and the software. And the patent system actually does not have the relevant logical thinking and the systems to protect software and patent. But the fact of the matter is, today, globally, 15% patents are around software. So if we become an important economy as far as software products are concerned, that at the same time we can actually become advocates to the fact that software needs to be protected differently. It need not, because it does not have a life of 20 years, so need not to be protected for 20 years, and have different models for protection, giving limited monopoly on the subject. But as of date, it is a fact that patents and copyrights are the key elements around which software needs to be protected. And that's it. Secondly, let's touch upon what government has done. As someone talked about, that startups face a lot of challenges as far as the IPR protection is concerned. For startups, we have done a few things. It's a fact that MSMEs and startups cannot have internal systems for protection of their IPRs or management of their IPRs. They need certain amount of external handholding for such support. And external handholding from private sector it comes with a cost. which in the strategic things of affairs, MSMEs and startups are not in a position to afford it. So government came up with three things. First, in the Startup India program, the filing fees has been reduced and it is 25% of what it is for the large companies. That is first thing. The second thing is that they have empaneled a battery of IPR attorneys at a fees which is reasonable and affordable by the startups and MSMEs, and they can actually use this. Then specific departments like ours, on sector specific, have done few things. Mahesh talked about the prior art search sector. Why we have done this? Let's understand that prior to you filing a patent, you have to understand two things. Is my invention or innovation worthy or a patentable subject matter as such or not? Second, does it give me a strategic or a commercial advantage if I file a patent? These are the two answers you need to do before you investing in filing a patent or an IPR. And this prior art search exactly does that for you on a complementary basis. It gives you these two answers which are very important prior to you filing a patent. Then in the ICT space, because patents have geographical boundaries, it's only applicable or enforceable in a geography where you have filed a patent. So India will not give you any advantage if you are in the ICT space because yours is a global market. Yours is the market, Korea, and these are the geographies where your technology has markets, where you have chances of being acquired by Oracles and the Apples and the Ciscos of the world and Google. So you need to have a global patent for that. A patent filed in few geographies can be of the tune of 30 lakhs to 50 lakhs per patent, and one patent does not actually give you patents, and you need to file multiple patents. So cost is a very key issue, and we 50% of your total international filing cost to a total of 15 lakh rupees per patent. That is the second thing. Third thing is that we need to have sector-specific knowledge of managing IPR. Most of the earlier conferences used to be journalist in nature, and if DIPP does it or a department which administers IPR will do it on journal clauses, but we need to talk on sector-specific. We need not to be talking on acts and laws and what does 65A and 3K say. As a sector or an industry, you can take strategic advantages, and our IPR awareness workshops are specifically targeted for those. We never talk about IP panorama, so if you want to get into further details on the subject, I will advocate that you go to our website and file a patent. Understand the subject in detail, and it takes around 1.5 hours?
Yeah, probably.
Approximately 1.5 hours, and you can do that at leisure times. It's available on your mobile also, so if you are traveling, so it's as an app you can download. And for that app, for motivating you for that app, that quiz is not for the reason that we want to actually test your knowledge. That quiz is for the purpose that we want to motivate you to download that app. Because you can't play the quiz unless you download that app. So I'll request you to at least participate in that quiz for the simple reason that you download that app. So these are some of the few things that this department is doing, other department, biotechnology is doing for the pharma sector and other things. But the limited point is that we need to move up the value chain. We need to create value around products and solutions in the IT space. For taking our IT industry to the next stage, and for importance that our products and solutions will be India specific and actually reap the benefits of the IT sector. Because understand that the Oracles and the Googles of the world, they give you solutions which they actually implement for a particular problem. Now take for example an automation of a municipality. There are 600 municipalities in India because we have around 600 districts. Why each district needs to have a separate tender for their automations? And each tender is around to the tune of around 100 crores. Why can't you have a single product? Because most of the specific applications will be what municipality does. It gives life and death certificates. Everyone does that. It gives you a caste certificate and all that. So why can't there be an ERP solution which is downloaded and customized in few hours for a municipality? But what you have seen in this country is that each municipality gives a project. It gets implemented in few years. Each one pays around few hundred crores for automation. And that's not the way poor countries need to do their IT. We need to move to product space. Now, the last point I want to touch upon is data. Here, and data and its protection. Cybersecurity for data is important, and that's a different subject. It's not a subject for this talk. But let's understand three things. We have a jam, or the India stack, what we call. 1 billion digital bank accounts opened in the last 2 or 3 years. A country with 1.2 billion mobile phones and a digital identity for 1.2 billion. Right? These are the 3 digital databases that we have. And now you create permutations around it. A simple probability statistic says that 1.2 billion into 1.2 billion into 1.2 billion. Just on these 3 things, we have these many 1.2 into 1.2 into 1.2 billion business opportunities. If we look at what is the power of data in this country. On top of it, we have recently implemented GST. Besides what all talks are on GST as a taxation system, but it will do one thing. It will create 1 trillion data sets every year because of GST. And the combination of these 4 data sets creates a $1 trillion business opportunity in this country. And no other country has got that opportunity. Because no one has a digital identity. No one can create 1 trillion data sets out of their GST because they are lucky to have 1.3 billion as our population. And no one has 65% of its population below the age of 35. So data is very important, and how do we protect data which is traditionally being protected by copyright? And how do we advocate and read through the privacy laws around digital data is a thing that we as a young population, not me, but you as a young population, should think about, that how do we actually rethink on the privacy aspect in this digital world, and where data is very important. Thank you once more. And
Thank you, sir, for taking us through the ICT inventions and patent perspective in India and Europe. We are obliged with your esteemed presence and knowledge. And I thank you on a personal note for your words of acknowledgement and appreciation. I'm highly motivated. Thank you, sir.